All right. Thanks, folks, for being here. The Civil Justice Full Committee today. If I can go ahead and ask the clerk to take the roll.
Representatives Bricken, Clemens, Curcio, Eldridge, Garrett, Gillespie, Griffey, Harris, Littleton, Ogles, Parkinson, Ramsey, Russell, Smith, Stewart, Vice Chairman Jernigan, Chairman Farmer.
Present.
Mr. Chairman, you have a quorum.
Okay, thanks so much. Members, anything anybody needs to recognize or say before we get started today? Doesn't look like it. All right, we have a calendar, and I'm going to go ahead and make a couple of announcements, or actually just one. Item 12, that's House Bill 2671. It's going to be rolled for 1 week, so without objection, rolled for a week. And that brings us to item 1 on the calendar. That's House Bill 2145 by Chair Lady Littleton, I believe, is recognized.
Great.
Second.
Thank you, Mr. Chairman. This bill comes from the governor's office or administration, and it is a two-part. The first part, it's an extension of foster care services. The first part of the bill will expand eligibility for extension of foster care services, a wraparound service program for young adults still in DCS custody when they turn 18. Eligibility will be expanded to include full-time employment and non-credit-bearing vocational training programs. Currently, eligibility is limited enrollment in school and work readiness program. So those that are aging out of foster care, if they want to go to work somewhere or to a secondary school, or they're going to be allowed to do that within this foster care program. In the past, if they didn't go to college, then they just were out on their own pretty much. So the second part of this bill will allow DCS to pay a per diem to relative caregivers instead of placing a child in full custody. DCS does not currently reimburse caregivers who assume custody of a child they are related to. This prevents many relative caregivers from accepting this responsibility, resulting in the child going into full state custody at a full daily foster rate. And under this proposal, DCS will reimburse caregivers at 50% of the daily foster care board rate for the level of care assigned to the child. And they would, this families that accept the child, the caregiver, they'll be checked on once a month, and they will be redetermined once a year. And 3 other states have done this very successfully: Ohio, Florida, and Arizona. So that's what the bill does.
Very good. I know we had quite a bit of discussion in children and families over this. Members, does anyone have any questions or comments for Chair Lady Littleton? Are we ready to vote? Oh, excuse me. Representative Bricken, you recognize, sir.
Thank you, Mr. Chairman, and I appreciate the chairman bringing this bill. Again, I think this bill has a lot of good points, and I know it will help the foster care program. I've stated in subcommittee, and I certainly want to just state at the full committee, that this bill still gives me heartburn in the largeness of government growth that it extends, and the funding and I just feel that DCS, needs to be, and I know when I say mindful of what I still feel like will be some backdoor abuse of these benefits. The third-party companies that DCS uses to verify the program are, I certainly hope they're going to do the job they're entrusted to do. About a third of the cost of this program is just for the third parties companies to administer the program. So I will certainly support the bill, but it still just, I'm going to say there's just things that it bothers me, and I'll just make that statement.
Very good. Members, any additional questions or comment for the Chair Lady? Chairman Shirley Littleton,
Thank you,
you're
Mr.
recognized.
Chairman. I did want to say that these families will receive all the wraparound services, so people will be inside the home a lot to check on each child and each family. So I think that should make us all feel a lot better. And it is proven that a lot of times when they go into foster care, they're moved around searching for a family. You know, they're not happy where they're at, so and they end up being moved 2 or 3 times. That slows them down in school and in their graduation, if they even graduate. So we think that these is a great start, keeping them with their family where they're happy. But they will have every wraparound service that foster children have as well.
Very good. And next most I have Representative Smith, you recognize?
Thank you, Chairman Farmer. And this is a question to a confirming question to the sponsor, Chairman Littleton, because I had this question answered of me with DCS, but I just wanted for the record, because I join, I worry about us growing growth, but as I understand this, if this particular child was not in the custody of a grandparent, then they would be in the custody of the state. So what this program will do is allow half of the reimbursing costs that would have gone to the foster family to go instead to the grandparent. So we're actually, we're keeping a child with their family member and paying half of the cost that we would have if they were in state custody. Is that a correct statement? Thank you, Mr. Chairman.
Shirley Littleton, you're recognized.
That is correct, but it's not just a grandparent. It could be like an aunt or uncle, a grandparent, or a great-grandparent. And I do have great-grandparents in my district that have raised their great-grandchildren. So they want to be able to take care of them, but a lot of times they just need that little boost of extra money and all of the services that we have to offer. So, and again, it does keep them in a home where they're happy with a family member, and it keeps them from changing so many times in foster care.
Very good. Members, any additional questions? Seeing none, looks like we're ready to vote to send House Bill 2145 to GovOps. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on. That brings us to item 2 on the calendar. That's House Bill 2163, I believe, by Representative Vital. Got a motion second, and I just don't see Representative Vital. So what we'll do, let's just go ahead and roll that to Hill. When he comes in, I'll bring him back up. So, yeah, roll to the Hill of this calendar, sir. This calendar, sir. So without objection, House Bill 2163 will roll to the Hill of today's calendar. Brings us to item 3, House Bill 1918 by Representative Whitson. Got a motion and a second, sir, and you're properly recognized.
Thank you, Mr. Chairman and committee. House Bill 1918. Currently, only circuit court judges in Davidson County are authorized to appoint a full-time master to serve as a judicial officer in the absence of circuit court judges. This legislation will allow any county in our state, not just Davidson County, to authorize the judges of the circuit and chancery courts to appoint masters to probate those matters that the appropriate judge may direct the master to hear. Approving and funding the position requires adoption of a resolution by 2/3 majority vote of the county legislative body. Persons selected for the position will be considered county employees in regards to pay and benefits. For instance, if approved and funded by my county commission, our circuit and chancery court judges could allow the appointment of masters to handle the probate docket regarding wills and guardianship cases. With that, Mr. Chairman and committee, I renew my motion.
Members, any questions for Representative Whitson? Seeing none, we're ready to vote to send Representative Griffey, you're recognized, sir.
Thank you, Mr. Chairman. Thank you for bringing this bill. My question is this, that you mentioned if someone's appointed a special master, they're going to be a county employee?
Representative Whitson, you're recognized.
Yes, because these positions have to be funded by the county.
Any follow-up, Representative Griffey?
No, thank you, Mr. Chairman. Thank you, sponsor.
Very good. Members, any additional questions? Seeing none, looks like we're ready to vote to send House Bill 1918 to Finance. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on. And, sir, you also have item 4, House Bill 2160.
Motion.
And you're properly recognized.
Thank you, Mr. Chairman. This bill, House Bill 2160, will expand the list of county constitutional officers who have the authority to perform marriages to include court clerks, register of deeds, trustees, and property assessors. Currently, county mayors and county clerks have the authority to perform marriages, as do county commissioners, judges, and notary publics. This is a permissive bill, as does not require any elected official to perform marriage ceremonies as part of their official duties. It merely provides legal authorizations for those who wish to perform marriages to do so, with the same rights and responsibility as local officials who already have that authority. This bill was brought to me by the Tennessee County Trustees Association, the Tennessee County Officials Association. With that, Mr. Chairman, I renew my motion.
Very good. Members, any questions for Representative Whitson? Representative Griffey, you're recognized, and I'll come to you, Chairman Garcia.
Thank you, Mr. Chairman. Would the trustees and assessors be allowed to charge a fee to conduct the marriages, or would that be part of their duties and salary that they already have as public officials?
Representative Whitson, you're recognized.
Thank you, and that's a good question. I checked with legal, and the question was, can a public official be paid for performing a wedding? Other than public officials mentioned already in the TCA, such as county mayors, county clerk, members of the county legislative body, and city mayor, the answer is no.
They cannot?
Cannot.
Okay, that's all I have. Thank you.
Very good. Chairman Curcio, you're recognized.
Thank you, Mr. Chairman, and thank you for bringing the bill. I think expanding access for people to get married is a good thing. I know when we did this for the General Assembly a couple of years ago, there was a provision where if we wanted, as members of the General Assembly, to solemnize marriages, we would need to register with the Department of Vital Records. Is that just a one-off for the General Assembly, or is that included for these folks as well? And if you don't know, it's okay.
Representative Whitson, you're recognized.
Right. I would assume it would be, they would have to register, but again, I cannot say that for sure.
Okay, no problem.
I'll find out for you and get back to you.
Okay, thank you.
Very good. Members, any additional questions for Representative Whitson? Seeing none, looks like we're ready to vote. Send House Bill 2160 to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on.
Thank you, Mr. Chairman, and thank you, committee.
Thank you, sir. That brings us to item number 5. That's by Representative Rudd. You got a motion and a second, sir, and then it looks like you have an amendment 013400. Is that something you'd like to?
That is correct. That makes a bill, and I appreciate it being on it.
Very good. You've got a motion and a second amendment, and you're properly recognized, sir.
Thank you. What this bill does, and the amended bill does, is we're correcting a minor problem that resulted from a few years of our actions on land that is purposely and knowingly landlocked. We would not allow an easement. This would not apply to that land. This would apply to land that was knowingly landlocked by the owner but provided an easement of access to that property, say such as to bale hay. But now they've decided to build a home on it. This would allow them to go back before a judge and ask for an additional 5 foot for a total of 15 foot to run utilities to the property.
Very good.
That's what the bill does.
Very good, members. Any questions on the amendment? On the amendment. Makes the bill. Seeing none, we're going to vote to adopt House Amendment 013400 to House Bill 1884. All those in favor say aye. Aye. Opposed, say no. Now we're back on the bill as amended. Any questions on the bill, members? Questions been called. Seeing no objection, we're here ready to vote on send House Bill 1884 to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on. Thank you. And members, without objection, I'm going to go ahead. I saw Representative Vital walk in. We had, sir, we'd rolled your bill to the hill, so without objection, we're going to bring that back out of order so you can. Very good. So that's item 2, House Bill 2163.
On behalf of the administration, and this bill is very simple. It specifies and clarifies that the average to be calculated for the monthly caseload for the Department of Child Services be done monthly, and to ensure that the number is consistent with the caseload of an average of 20 clients that they serve each month.
Very good.
Very simple.
And members, I believe we had a motion and a second on the bill. We had pulled it back from behind the calendar here, so we're good there. Any questions for Representative Vital on this? Representative Garrett, you recognize, sir.
Thank you, Mr. Chairman. Representative Vital, is this your first bill?
It is not.
It's not your first
I'm
bill.
seasoned.
It's your first bill that I've seen, so that counts enough. Or at least I think this committee has seen, and you were awfully late. We called your bill, you weren't here. Mr. Chairman, I think this bill should be rolled to the last calendar. That was awfully quick.
That was quick, wasn't it?
I'll withdraw my objection. Hopefully next time Representative Vital can be on time when his bill is properly called. What do you think about that?
That's right.
I humbly seek your advice, and this is a vital bill to child services.
I appreciate the bill.
Very good, very good. That's good, that's a good one. Representative Ogles, you recognized.
Thank you, Chairman, and to the sponsor. Simple bill, good bill. I love the sponsor, but those are usually signs of red flags just in the future. But we support your legislation. Thank you for being here as tardy as you are.
All right. Members, anything else for our good and kind Representative Vital? Seeing none, looks like we're ready to vote. Excuse me, Representative Parkinson, you recognized.
Thank you, Chairman, for recognizing me, and thank you for bringing this bill. Honestly, you know, one of my constituents brought this issue, worked at DCS, and brought this issue to me a few years ago. And they can't keep people because of the level of their caseloads, and people is always turning over. So I'm really, truly appreciative of this legislation, and actually want to sign on to the bill too. They gave you an easy one though. They gave you an alley-oop. I just want you to know that. Thank you, sir.
That's right. All right, members, anything else for Representative Vital? Seeing none, looks like we're ready to vote. Send House Bill 2163 to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on.
Thank you.
All right, folks, now we're going to move back down to item 6, House Bill 1724 by Representative Moon. You got a motion and a second. You're properly recognized, sir.
Thank you, Mr. Chairman. I'm here today to ask this committee to move a bill forward. House Bill 1724 adds veterans groups to the list of other nonprofits that are immune from suit except for conduct that is willful, wanton, or gross negligence. In our last VFW meeting in Maryville last Thursday, I asked the members what a 501c19 was, and 30 people couldn't answer it. They said we're a 501c3. And I think that's some of the confusion that we've dealt with over the years. And examples of 501c19s are the Veterans of Foreign War, American Legion, DAV, Military Order of Purple Heart. Like I say, this is just adding those to the list that are immune from suit, except for gross negligence. And I know you have a lot of requests, but I'm just asking that you put veterans at the same level that a nonprofit garden club enjoys.
Very good. Members, do we have any questions for Representative Moon? Seeing none, looks like we're ready to vote to send House Bill 1724 to calendar and rules. All those in favor say aye. 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 Opposed, say no. Ayes have
Thank you,
it.
Mr.
Bill moves
Chairman.
on. Thank you, sir. Brings us to item 7. House Bill 1765 by Representative Parkinson. You've got a motion and a second. Looks like you have an amendment there. 013375. Yeah, go ahead. He does. He's got a motion and a second on the bill.
Thank you,
I do
Mr.
not
Chair.
have a motion or a
Thank you,
second
thank you,
on
committee.
this amendment.
Thank you. And thank you.
013375, sir.
Yes, sir.
Does
And
that
thank-
make the bill? The amendment?
Yeah, it did. I think it did rewrite the bill. I would have to refer to Michelle. It does rewrite
It does, okay.
Right, okay. Thank you for that. And members, what this bill does, it raises the threshold for 501c3 organizations that are providing services specifically in this area, providing food to the community, providing housing, or providing shelter from adverse weather. And it's specifically in those spaces, in those acts of service, that it raises the tort threshold for these organizations. And I also want to say that, I want to thank the subcommittee again, for their help on it, because it kind of reminded me of the olden days when the whole committee would help to make a bill better and you get the bill through. And I hope that serves as a model for us to go back to again. But thank you again.
Sounds good. Members, we have any questions for Representative Parkinson on the amendment? We're on the amendment. Seeing none, looks like we're ready to vote to adopt House Amendment 013375 to House Bill 1765. Those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. Members have any questions for Representative Parkinson on the bill as amended? Seeing none, looks like we're ready to vote. Send House Bill 1765 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it.
Thank you, members. Thank you, committee. Thank you, Mr. Chair.
Thank you, sir. That brings us to item 8, House Bill 1847 by Chair Lady Littleton. Got a motion and second, and Chair Lady, I have a couple of amendments here in front of me. I have 013462, and then 13808.
I want to move forward with 013808, please.
Very good.
Second.
Got a motion and a second on the amendment. Does that make the bill?
It does make the bill.
Very good.
All right.
So you're properly recognized.
Thank you. So the amendment says the Department of Children's Services contracts with the non-governmental entities to provide foster care services to children in state custody. This legislation limits the liability of those contracted entities and employees by extending the department state's limited tort exposure to the entities and employees providing the services under the contract with the Department of Children's Services. The only difference between the amendment and the subcommittee amendment is the inclusion of some language from the Department of Children's Services that clarifies the scope of the immunity to only apply to the claims from the service population. The state's limits, which are being transferred to the contracted agencies, are $300,000 per claimant, or $1 million per occurrence. No limits will be provided in the event of gross negligence in the performance of the contract. So the current law, Chapter 499 on the 11th General Assembly, largely removed the statute of limitations on the child abuse cases. So the proposed change, the legislation is intended to extend the same limited tort exposure that the Department of Children's Services enjoys to the contracting agencies' employees providing services under contract with the Department of Children's Services and services to children in state custody. So the reason for the change is agencies providing services to foster care children were having great difficulty obtaining insurance coverage due to the unknown nature of the future claims. This legislation is meant to assist as many carriers were refused, refusing to write insurance for these providers on the premiums were skyrocketing after the passage of the legislation in 2019.
Very good. Great explanation. Members, we have any questions for the chair lady on the amendment? Representative Griffey, you're recognized, sir.
Thank you, and thank you, Chair Lake, for bringing this legislation. Here's just a concern I have, and hope maybe you can answer it, or maybe legal could answer it. It's my understanding that continuum of services by DCS or their third-party contractor can sometimes involve transporting a child or someone in foster care services to different locations, doctor visits, therapeutic counseling sessions, and so forth. If a third-party contractor is doing the transporting in their vehicles or whatever, and has is a cause of an accident with some other Tennessean on the road, is this third-party contractor going to get the limitations of liability that typically we reserve only to state actors because it is a state, or is that something outside the purview of continuum of services?
Chair Lady Littleton, you're
Could
recognized.
you check with legal about that, please?
Sure. Without objection, we'll go to session. We'll hear from legal.
Michelle Fogarty, Legal Services. I read it to say that they would have the same tort liability limitations as DCS. So they would be limited to the $300,000 per individual or $1 million per occurrence.
All right. Representative Griffey, any follow-up?
For legal, and that would include simply transporting in their vehicles or something like that. They would get the protection the state normally reserves for state actors.
It says they're granted limited tort exposure under this chapter from civil actions or claims filed by the children and families who are the intended or actual recipients of the services. And they get the same limited tort exposure as the Department of Children's Services does.
Thank you.
Very good. Members, anything else for legal while we're out of session? Representative Clemens, you recognize.
Yeah, thank you, Mr. Chairman. And can you say the dollar amount that tort cap is limited at for the Department of Children's Services?
Ms. Fogarty?
It's $300,000 per claimant or $1 million per occurrence.
Very good. President Clemens? Very good. Members? Anyone else? All right, let's get back in session. So we're back on we're on the amendment. Representative Griffey, you recognize.
Thank you, Mr. Chairman. I just, I'm concerned and would like to express my concern of doing this. These third-party contractors that are doing this work, they are commercial entities. They're in business and they, assuming, making money for doing this. So I don't feel comfortable granting them the same sort of limited tort exposure that we reserve for state actors. because I don't know that this necessarily has to be a nonprofit independent contractor. That's my thoughts on it. Thank you very much.
Very good. Shirley Littleton, any response or anything? Okay, very good. Representative Smith, you recognize.
Question of the sponsor is, because these mental health facilities have fallen under previous legislation by this legislative body, they have no other alternative except to look for a third party. And so what I'm understanding your bill does is it allows that favorable rate and the same coverage to be awarded through a surrogate insurance company to the mental health facility that is supplying the services that a state would. Am I simplifying it too much? Because I don't. While I'm not a big fan of insurance companies. I think my reputation precedes itself. But in this case, I think that the mental health facilities are just trying to find a way to find cover of tort, and they want to receive the same rates that they would have if other legislation hadn't prevailed. Thank you, Mr. Chairman.
Shirley, any response?
That's correct.
Very good. And the next one is Representative Garrett.
Thank you, Mr. Chairman. Madam Chairman, thank you for bringing this legislation. I appreciate your efforts on trying to make this legislation as narrow as possible to apply in this specific instance, so we're not expanding any immunity that the state has. And that's a bad word, not immunity. The lower the limits, and to address some concern that was stated by the former member today is that, most likely in a transport situation, you're going to have insurance covering the vehicle. That's not going to apply. So even if there is a loss, now granted, obviously insurance, we all need insurance to minimize the risk. That particular commercial vehicle may not have insurance, but they've got to go through a rigorous approval process to become a contractor. So that's most likely one of those questions they're going to ask is, do you have proper coverage and insurance on your vehicles, et cetera? And they probably most likely have to apply proof of that. So in an accident-related situation that we're going to have in a vehicle, most likely going to be a commercial policy that's going to cover something like that would apply. So that minimized my concern that Representative Griffey brought up, which I completely understand. So I appreciate this legislation because we need these independent contractors that provide this service. If we do not and they cannot find insurance, we simply will not have the ability to protect these children. So I really appreciate the bill, Madam Chair. Thank you.
Very good. Madam Chair.
Thank you. We have worked with all the stakeholders, and that's why we had a few amendments, but we thought everyone's happy with this. We made it as close and tight as we possibly could.
Very good. And I have Representative Clemens. You're next.
Thank you, Mr. Chairman, and thank you, sponsor. We discussed this a little bit in the subcommittee, and this is a problem, obviously, because they didn't want to provide policies because of the unlimited duration of time, and I expressed concern then, and I still have it now, that we're creating a tort cap rather than creating a statute of limitations. But if we create a statute of limitations, that violates and kind of goes against the spirit of the bill that we're trying to fix and further here. So it's a really challenging situation. And I'm not sure by creating a tort cap is the best solution in this scenario. So my question is, rather than trying to fix it on that end, was any consideration given to making a requirement or creating, forcing the insurance companies in some way to cover these entities that provide these vital services for the benefit of children that would comply with the spirit of the bill that we passed a few years ago?
Shirley Littleton, you're recognized.
We were in contact with several people, all the stakeholders, and this is something that we all agreed on. So we think this is the best opportunity.
Very good. Representative Clemens.
Yeah, the state of Tennessee is in charge of regulating the insurance industry, and if the insurance industry is the problem here in preventing us from being able to carry out the intent of that legislation that we passed to protect the interest of children who may have been abused or something at some point in time, I think maybe regulating the insurance industry or approaching it from that direction may have been more effective than creating a tort cap, which would limit a child's ability to collect for a wrong, regardless of how distant in the past. So thank you, Mr. Chairman. I appreciate the time.
Right. And I have Representative Ogles. Do you have your hand up? I thought I saw a glimmer of hope on there.
Yes, Chairman. Yeah, this is a problem. I understand the fact that we're trying to fix the ability for insurers to insure, but I would like to mirror the representative's comments. I hate that we're putting tort liability caps on children and the care of, if that's in fact what we're doing, if that's how I understand this, I just felt like this committee, more than any, has shown a willingness to protect children and do everything in our power to be sure that they're given all opportunities that under the law. So I hate that we're capping a claim that could be in the future, especially after a criminal claim that could come through. I just hate that we're capping their civil recourse, I guess is the right way to say it. I'll look at my lawyers and I'm seeing them nod on the committee. That's very problematic to me, and that gives me pause. Chairman, thank you.
Very good. And I want to remind members, this is $300,000. That's a significant amount of money. Very rarely will you see, it's not every day that lawyers go in the courtroom and win a case and get $75,000 or $100,000. $300,000 is a significant amount of money. Of course, nothing can replace a situation where a child's been abused, right? It's never, no amount of money can fix that or ever take that back. But I do want to remind members, this is a significant amount of recovery that they would be eligible for. To keep that in mind. I do have Representative Stewart on the list next, and actually, Chair Lady, I want to recognize you first, and then I'll go.
Thank you, Mr. Chairman. This is the same amount, the same caps that DCS uses now.
Okay.
So it's the same that goes with the department, so that's why we chose it.
Okay. All right.
Thank you.
Representative Stewart, you're recognized, sir.
I just was curious, Madam Chairman, do we know how many of these organizations are providing these services, or what percentage of our children are under the auspices of these organizations?
Very good. Chair Lady Littleton, you're recognized.
I had that somewhere, but I don't remember.
And if that's something that we need to get
Yeah,
to
we'll get that.
Representative Stewart, we can get that to you, sir.
Yeah, I guess I would just say I share the representative's concerns. I know a recent case in Nashville of an injured child. It's, a $3 million recovery, I think. So I just worry about extending these caps when you're dealing with children. Thank you.
Members, I have Representative Griffey. You're next, sir.
Thank you, Mr. Chairman, and I appreciate the effort, what we're trying to accomplish. What our concern is that we may be going much further than what we actually intended, because we are talking about children who may have suffered an injury. We're not only capping the damages, we're also completely changing the standard of care of what a person is generally entitled to, and that's somebody else in the community act as a reasonable, prudent person towards them in whatever action they're engaging in. And my concern is, if you do cap these damages, you may actually prevent some children from even having a lawyer be interested in taking that case and pursuing it. Because if the damages are capped, they're going to go, look, you probably got screwed over. I'd have to prove gross negligence. And even if I do that, I'm going to be capped. Well, I guess if it's gross negligence, I can get more than the caps. But ordinary negligence, it's, $300,000. It's just not worth it. And so I'm worried that, some children may actually not be able to get good representation if they have suffered an injury. So thank you very much. I appreciate the sponsor's effort. I just kind of wonder if this is the best way to do it. Thank you.
Very good. And I want to remind members, we're still on the amendment. Any other questions or concerns on the amendment? Seeing none, looks like we're ready to vote to adopt House Amendment 13808 to House Bill 1847. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. Any questions for the Chair Lady on this bill as amended? Seeing none, looks like we're ready to vote to send House Bill 1847 to Calendar and Rules. All in favor say aye. Aye. Opposed, say no. No. Ayes have it. Bill moves on. And that brings us to item 9 by House Bill 1665 by Representative Smith.
Thank you, Chairman and committee.
You got a motion and a second. You're properly recognized, ma'am.
Thank you. And there are no amendments. The bill is submitted as written. I'm carrying this bill at the request of chancellors in Hamilton County who have worked with their colleagues. And this essentially will make standard both the handling of absentee and non-absentee estates or probate law. In this particular case, current law allows a legislative body at the county level to appoint or elect a public administrator, public guardian, or trustee. This bill will allow a chancellor or a probate judge to appoint a public receiver for the purpose of assessing the estate and the lack of the will or a will, and then to report back to that court and make a determination if a permanent or a temporary receiver should be put in place. This will prevent diminution of value of the estate and protect the assets for not only creditors but also those named in the will. And with that, Mr. Chairman, I'll be happy to take questions.
Very good. You heard the explanation, members. Any questions for Representative Smith? Seeing none, looks like we're ready to vote to send House Bill 1665 to calendar and rules. All those in favor say aye.
Aye.
Opposed, say no. Ayes have it. Bill moves on. Thank you. That brings us to item 10, House Bill 1906 by Chairman Curcio. You got a motion and a second, sir, and you're properly recognized.
Thank you, Mr. Chairman and committee. Hopefully this will be the shortest bill you see all year, but it adds the word deeds and or to the existing subdivision C2 in Tennessee Code 67-1-1403.
Very good. You've heard the explanation. Any questions for Chairman Curcio? Members, any questions for the chairman? Seeing none, looks like we're ready to vote to send the House Bill 1906 to calendar and rules. All those in favor say aye.
Aye.
Opposed, say no. Ayes have it. Bill moves on.
Thank you, Mr. Chairman and committee.
You're welcome. That brings us to item 11, House Resolution 130, 0130 by Chairman Curcio.
Thank you, Mr. Chairman.
A motion?
Second.
Very good.
What this does is just ratifies the amendment to the revisions of the Tennessee Rules of Evidence by the Tennessee Supreme Court.
Very good. You've heard the explanation. Anyone have any questions for Chairman Curcio? This is something we do, what, every year, Mr. Chairman?
Yes, sir. We do this every year.
Very good.
Unless we forget to do it.
And that's happened before, and that's okay. That's okay. So any questions or concerns for the chairman? Seeing none, looks like we're ready to vote to send House Resolution 130 to calendar and rules. All those in favor say aye.
Aye.
Opposed, say no. Ayes have it. Bill moves on. And I want to let Vice Chair Jernigan take up the last two bills on the calendar for me.
Thank you, Chairman Farmer.
Very good.
Members, we are at item number 13 and House Resolution 133 by Chairman Farmer. Got a motion and a second. It's probably before us. Chairman Farmer, you are recognized.
Thank you. And this does, just as Chairman Curcio just did, but this does this same thing for the Tennessee Rules of Civil Procedure. So just ratify the Tennessee Rules of Civil Procedure is what this does.
Question's been called. We're going to be voting on House Resolution 133 to go to calendar and rules. All those in favor say aye. Aye. Those opposed? Ayes have it on the calendar and rules. Brings us to item number 14, House Resolution 134. Motion. Got a motion and a second. It's probably before us. Chairman Farmer, you're recognized.
Thank you, members, and Mr. Chair. What this does is it ratifies the Tennessee Rules of Appellate Procedure. The Tennessee Rules of Appellate Procedure.
Seeing any questions being, you have
great.
Chairman Curcio.
And do we do this every year, Chairman?
Yeah, we do.
Okay.
Except,
Thank you.
You know, thank you.
Unless we forget.
Unless we forget.
Yeah, right. I got it. Okay.
Unless we forget. Okay, now I'll entertain a question. Okay, it's been called. Without objection, we're going to vote on House Resolution 134 by Chairman Farmer to go to calendar and rules. All those in favor say aye. Aye. Those opposed, ayes have it on the calendar and rules. Chairman Farmer, it's back to you.
Well, that concludes our calendar day, members. So without objection, we're going to adjourn till this time next week. Thanks so much.